Supreme Court of the State of Oklahoma is now in session. God bless the United States of America, the State of Oklahoma, and this honorable court.
Thank you, everyone. Please be seated. Good morning, everyone. Before we begin, let me ask all counsel that are present and have entered an appearance in this case before the date that we said earlier, if you'd please just stand and state your name and for whom you appear. It would assist the court, please. Start with the petitioners. Thank you. Counsel. Thank you. All right, thank you. We had an email sent to you. What I want to do is allow you first to summarize your argument without interruption. You're certainly not obliged to take all the time allotted. I would encourage you not to, matter of fact. But after which we will certainly have questions of you. And Mr. Davidson, I believe you are first, please, sir, and you've allotted 25 minutes for your first argument. Is that right, sir? All right, you may proceed, sir.
Mr. Chief Justice, and may it please the court, validation of the petitioner's bonds by this court is proper for 3 reasons. First, notice of these proceedings has been given in compliance with the requirements of Title 69, Section 1718. Second, the authority has complied with all technical requirements for the issuance of its turnpike revenue bonds pursuant to Section 1709 of the Enabling Act. And third, the bonds to be issued will fund statutorily enumerated projects and refund outstanding indebtedness of the authority, as authorized by Sections 1705 and 1719 of its Enabling Act. The authority was created in 1947 for the sole purpose of providing an instrumentality of the state to construct, operate, maintain, and repair turnpike projects, which have been deemed to be public highways. The authority's legislative mandate is to facilitate vehicular traffic, remove the present handicaps and hazards on the congested highways of the state, and construct express modern highways which embody reasonable safety devices. As provided in the Enabling Act, in at least 12 prior decisions of this court, the authority is vested with broad discretion to determine all or any part of which legislatively authorized turnpike projects to construct, as it determines to be feasible and economically sound. The legislature has provided these broad powers to the transportation experts at the authority to help create a transportation network which seamlessly combines the state tax-supported highway system with the turnpike system to provide safe, efficient corridors for the traveling public. 75 years and 630 miles of roadways later, that mandate continues. However, the infrastructure, traffic, and safety needs of Oklahomans continue to evolve as new technologies are invented, population growth continues, and the major metropolitan areas continue to expand. Earlier this year, the authority announced its 15-year, $5 billion Advancing and Connecting Communities and Economies Safely Statewide, or Access Oklahoma initiative. Access Oklahoma is about safety and provides for reinvestment in turnpike infrastructure statewide, as well as affording relief along the congested I-35 corridor, which continues to see exponential traffic growth and an increase in serious vehicle accidents. This will primarily be accomplished through the construction of the Tri-City Connector and East-West Connector, which are the final components to complete the Oklahoma City Outer Loop as authorized in 1987, as well as construction of the South Extension, which is a component of authorization added in 1993. So why are we here? Under Section 1718 of the Enabling Act, the authority has the discretion to file an application with this court and invoke its original jurisdiction to seek a judicial determination on the validity of a proposed bond issuance. This court has previously ruled that it has jurisdiction to not only validate an issuance of bonds pursuant to the Enabling Act, but also to pass upon the sufficiency of the legislative authority to construct and operate turnpikes. The authority filed this original proceeding in response to the protesters' filing of a case in the District Court of Cleveland County challenging the funding and construction of the proposed Access Oklahoma projects. This proceeding has provided notice to the citizens of the state of Oklahoma of the authority's intent to issue its bonds to accomplish the funding of the Access projects, as well as refund outstanding indebtedness of the authority. With respect to whether 1705 authorizes the proposed routes for the Tri-City Connector, the East-West Connector, and the South Extension, Section 1705 identifies 35 individual projects of which all or any part are authorized to be constructed by the authority at such locations and on such routes as it, meaning the authority, shall determine to be feasible and economically sound. The descriptions of these projects vary, but that is by design, as the legislature has vested the exclusive power to the authority to determine in its sole discretion which projects to determine to be feasible, design, and construct in accordance with statutory authorization. This includes the entirety of a route, potential interchanges, and the discretion to start and end turnpikes in the vicinity of authorized locations. As this court stated in Owens versus OTA in 1954, once the authority has selected and designated a route, the courts will not inquire into the matter for the purpose of demanding why some other route was not chosen. The Tri-City Connector and East-West Connector are the last remaining segments to complete the Oklahoma City Outer Loop and were authorized over 35 years ago at Section 1705E, subsection 20. Construction of the loop commenced in 1989, following a bond validation proceeding wherein the court approved the proposed bonds and found the projects had been statutorily authorized. That initial issuance funded Section 1 of the loop, which ran from I-35 to the now Lake Hefner Parkway. Since that validation over 33 years ago, the authority has constructed 4 additional phases of the outer loop through the issuance of 7 series of turnpike revenue bonds as authorized and contemplated by the Enabling Act, where the authority is permitted to construct all or any part of the cost of one or more turnpike projects. This includes the most recent phases, which include the Kilpatrick extension south of I-40 and the Kickapoo turnpikes, which were challenged by protesters in 2016, where this court found that the projects were authorized and validate their issuance for their completion. The route of the Tri-City Connector provides for the construction of a turnpike facility from just west of the Will Rogers World Airport to just north of the South Canadian River along I-44. The route of the East-West Connector runs from the Tri-City area east to I-35 and then continuing east along Indian Hills Road, supporting the cities of Moore and Norman, and then extending up to I-40 to connect to the Kickapoo Turnpike east of Tinkerfield, thus completing the outer loop. The South Extension was authorized in Section 1705E28 in 1993, and importantly, is a separate and distinct authorization from the Oklahoma City Outer Loop authorized in 1989. The first 2 phases of this project included the Canadian River Bridge crossing south of Mustang, which was completed by ODOT, followed by the completion of the Norman Spur from the H.E. Bailey Turnpike to U.S. Highway 62, which was financed through a bond issuance of the authority in 1998. Since the completion of these first 2 phases, ODOT has received significant grant funds to complete the transformation of State Highway 9 from U.S. Highway 62 to I-35, accomplishing a significant piece of the 1705E28 authorization and making a tolled facility in this area redundant at this time. However, as can be seen from the text of the statute, the project provides for 2 distinct river crossings of the South Canadian River, one south of Mustang and an additional easterly crossing near Norman. The particular route of the South Extension was selected to address where traffic begins to become congested along I-35, provide for a perpendicular and easterly crossing of the South Canadian River through rural areas to minimize impacts to highly populated and developed areas, and provide space for the necessary infrastructure so as not to create unsafe driving conditions for any of those facilitating our roadways. Just as important is what's not in Section 1705E28. It does not provide direction with respect to where in Mustang the projects are to start and end, where the river crossings should occur, how or where connections are to be made with existing highway infrastructure, the location of toll collecting facilities, or the precise locations of the route. Rather, 1705E specifies that it is within the sole discretion of the authority to construct turnpikes at such locations and on such routes as it determines to be feasible and economically sound. In 12 prior validation proceedings, this court has never found a route to not be authorized. That's because the legislature has provided very broad authorizations and vested the exclusive ability to the authority to determine the location and routes as the authority deems feasible and economically sound. This discretion is particularly important when it comes to an authorization like subsection 28, where you must navigate additional hazards, including 2 significant highway crossings and 2 significant river crossings. The authority needs this flexibility to deal with the transportation needs through the passage of time and other factors, such as environmental concerns, changing riverbanks, population growth, and development. The proposed route of the South Extension takes all of these factors into account. From an engineering perspective, the largest barrier to construction of a roadway facility is a river bridge crossing. Bridges are expensive, and you want that river crossing to be as perpendicular as possible to create the shortest bridge spans you need to get across it. Likewise, the authority is mindful of the development that has occurred along the I-35 corridor in the 29 years since the authorization took effect, and especially around Norman and Noble. These alignments focus on eliminating safety hazards and integrating the existing highway infrastructure to help facilitate the flow of traffic while minimizing cost and disruption to private property. The authority does not operate in a vacuum, and the flexibility to determine the routes, alignments, and connections to existing highway infrastructure are an essential part of the powers legislatively delegated to the authority to meet its legislative mandate of facilitating vehicular traffic, relieving congestion on the highways, and removing the economic burdens on the tax-supported highway system. With respect to 1705F, in 1987, when the legislature authorized portions of the Oklahoma City Outer Loop, it also added authorizations for the Creek and Cherokee turnpikes. Simultaneously, 1705F was amended to provide that any bonds issued for the construction of proposed turnpikes, referred to in subparagraphs 10, 20, 21, and 22, shall be issued as one issue for all 4 of the proposed turnpikes and shall be financed, constructed, and operated under one bond indenture. The 1987 Act represented the first and only time the legislature has conditioned the building of projects upon one another. But the clear intent of the legislation was to provide for the construction of 2 rural and 2 urban turnpikes. As previously mentioned in 1988, the authority filed its application with this court, seeking validation of an issuance of bonds to construct the 4 projects identified in the 1987 Act as one issue under one bond indenture. The 89 bonds are important because it was the first opportunity that the authority had to consolidate all previously constructed turnpike facilities with new turnpike facilities into one master trust agreement. In the 89 validation proceedings, the authority specifically requested the court approve the issuance of bond for these 4 enumerated projects in compliance with the requirements of Section 1705F. Upon the issuance of those 1989 bonds, the provisions of 1705F were fulfilled, and those proposed turnpikes then became defined turnpike projects, as defined in Section 1704, subsection 2. In fact, after the issuance in 89, the Cherokee and Chickasaw turnpikes were fully built out to their feasibility and economic soundness. The Creek Turnpike has now been fully built out for over 10 years, and the Oklahoma City Outer Loop has since been financed through 6 additional series of bonds since 1989, with only the Tri-City Connector and East-West Connector remaining to complete that authorization. Again, it should be noted that in 2016, the provisions of 1705F were before this court when protesters challenged its provisions as violating the Constitution's single subject rule. Rejecting that argument, this court noted the ability of the authority to finance projects in stages and pay all or any part of the cost of one or more turnpike projects. It also noted the adoption of the Master Trust Agreement and that the components of the Kilpatrick and Kickapoo Turnpike projects were additional construction of the Oklahoma City Outer Loop validated in 1989. Neither this court nor the Enabling Act require the construction of a totality of an authorized project. Rather, that should be left to the legislatively delegated discretion of the authority based on feasibility and economic soundness. The clearest evidence that the legislature did not intend an all-or-nothing approach in financing the projects in 10, 20, 21, and 22 is found in the text of the authorizations themselves, which provide that the authority is authorized to construct a turnpike or any parts thereof, all or any part of an Oklahoma City outer loop, all or any part of the South Tulsa bypass, a new turnpike or any parts thereof. If the legislature meant for there to be only one opportunity to finance and construct the projects in their entirety, then it would have limited each authorization to a turnpike or all of a turnpike as the descriptor for each authorization rather than the all or any part thereof. The authority is before the legislature each and every year, where the authority apprises our elected officials of projects they are considering and those that have been completed. Likewise, if it was not the intent of the legislature when they added the provisions to 1705F, they would have amended or repealed the authorizations for those projects after their initial completion. The legislature has not repealed the project authorizations at issue today, but in fact did amend the authorization for the Creek Turnpike to add additional construction of that facility in the 1990s. However, the legislature has also regularly added or repealed other projects in 1705F since 1993. I count at least 16. Thus, the law with respect to financing turnpike projects is well settled. Each authorization in 1705E exists because the legislature has determined that the authority is in better position to construct those projects rather than the tax-supported highway system. The authority is the sole entity to construct turnpikes at such locations and along such routes as it deems to be feasible and economically sound. Not the legislature, not ODOT, not the courts, not cities, and not private citizens. Legislative authorization exists for each series of improvements to the turnpike facilities, including the Tri-City Connector, the East-West Connector, and the South Extension. These projects fulfill the statutory mandate of the authority to facilitate vehicular traffic and remove the hazards and handicaps on the congested highways of the state. The authority continues to operate today under its statutorily authorized powers, just as it has for the last 75 years, which have been upheld 12 prior times by this court. The petitioner respectfully requests this court uphold those prior decisions and validate the issuance of bonds. Thank you.
Counsel, you, on page 3 of your initial brief, do you have that in front of you?
I do not, but I can grab it, sir.
We grab it?
Yes, sir. Yes, sir.
You mentioned early on in your statement the Owens case.
Mm-hmm.
You did not mention these two below that one in 1966 and the other 1961. Any reason why you didn't mention those?
No, sir. I just believe that authorization is fully settled, at this point. Those particular cases were taken up in validation proceedings, which brought new and novel ideas. The 1961 and 1966 cases were the first time that the authority actually combined projects.
You think those are applicable here?
Excuse me?
Do you think those are applicable here?
Absolutely, Your Honor.
Well, I don't. If you look at that first case, that was actually a single bond issue, if I recall.
The 66 case?
Yeah. Well, nonetheless, under the statute that we're working under, my understanding is it was passed in 1968. Am I wrong there?
That is correct.
Counsel, is it your position that the Turnpike Authority can build a turnpike anywhere in the state without an authorizing statute?
That is not correct.
And so today you're asking for approval of the bond for the southern extension based upon Section 28 of the statute?
Yes, sir.
And that's the only statute you have in your toolbox for approval, is that right?
That is correct, sir.
So how should this court interpret this statute? Should we read the text and interpret the explicit text, or should we look at the legislative history?
Your Honor, I believe you have to look at the text. And if you look at the text, it provides a very general authorization from the vicinity of Mustang to the vicinity of Norman. And We've broken that out basically into 4 distinct phases. The authorization that's been completed by ODOT with the South Canadian River Bridge crossing, the second component being the construction of the turnpike, the Norman Spur from H.E. Bailey to Highway 62. The third component, which takes up a significant component of that easterly direction as identified in the statute from Highway 62 to I-35. However, the authority is trying to give the full intent to the statute of providing that second easterly river crossing and ending at a point in the vicinity of Norman. The statute itself, 1705.1, provides that the authority is authorized to determine the locations and of all termini of the facilities. The 1950 case of the application of the authority said it was within the discretion to not only determine the route, but also the termini of those facilities. That case dealt with terminating outside of Oklahoma City and Tulsa. That project was about 10, miles from each the destination points here. And this court held that that was appropriate.
Well, you mentioned Highway 9 was by federal grant resurfaced and expanded after the 1993 statute that you rely upon today.
Yes.
But if you read the statute, doesn't it basically define the current Highway 9 route that now is no longer needed to be added as a tollway?
It really doesn't, Your Honor, because if you look at the way that the Enabling Act is set up in Section 1705E, the authority is the person that is authorized to determine the locations and routes of those projects. The authority could have chosen to utilize Highway 9 at that time or not. And just because it's not completing a tolled highway facility between Highway 62 and I-35 today doesn't mean that there won't still be that need in the future. And the authority is reserving that right to be able to construct that facility at a future point.
So you're telling us that if Highway 9 had not been by federal grant rebuilt and connected from the spur to 35, that you would still stand here today and seek the south extension where you seek it?
Absolutely, Your Honor.
What about the legislative history? Does it weigh in your favor on this statute?
We think it does, Your Honor. And
Wasn't there a bill in 1999 submitted to the legislature to create the south extension in basically the same direction that you seek today that failed in the legislature?
Yes, Your Honor.
Didn't then Secretary Neil McCaleb make a public statement that he had abandoned the south extension?
Your Honor, that is absolutely true.
It's been dormant now for 23 years, has it not?
That the extension was abandoned basically through the uproar and contention of the citizens of Norman at that time. Absolutely. Did he say he was abandoning it forever? Absolutely not. Just at that particular time. The legislative history in 1999, what's interesting about those 2 pieces of legislation is that they were assigned to committee and votes were never actually taken up on those 2 pieces of legislation.
But why would they be sought? Why would legislation be sought for the south extension if the statute already authorized it?
Your Honor, respectfully, we've gone through the OTA records and we can find no point of where there was a request for those 2 pieces of authorization.
Okay,
Legislatures
Let's
continue.
move on to the one bond issue, F. Is it your position that we also should interpret this statute based upon the text or legislative history?
I think you can also look at the text and the legislative history, Your Honor.
So the last 3 words, looking at the text, one bond indenture, is that defined in the statute?
The bond indenture is not defined in the statute. It's defined as a trust agreement, Justice Rowe.
And so if we are to interpret this text, one bond indenture, how do we find that the Series 2022 are not additional bond indentures to these projects?
Well, I think you have to look at the issue that was completed in 1989, Your Honor. The purpose and statute was fulfilled in 1989 with the issuance of the adoption of the Master Trust Agreement and the first supplemental trust indenture or bond indenture that completed those 4 projects.
Well, was there a bond issued in 1999? I'm sorry, 1989.
There was a bond issued in
And you're
1989.
seeking another bond issue today.
That is absolutely correct.
And you're saying 33 years later,
Yes.
it still constitutes, your subsequent request today constitutes one bond indenture as contemplated by the statute.
No, Your Honor. Our contention is that we fulfilled the requirement of issuing those bonds in one series in one bond indenture in 1989, and that purpose was fulfilled completely in its entirety with the issuance of those bonds in 1980.
So you can see that this bond is not the one bond indenture referenced in Section F.
That is correct.
And how is this not violative of that language?
Because 1705F notes proposed turnpikes. It notes proposed turnpikes in two particular locations. Proposed turnpikes for the 4 enumerated authorizations. The authority is authorized to complete all or any part of a project. However,
Excuse me, in the legislative history, isn't the record replete with news articles and legislative history that then Governor Bellman said this was an all or nothing proposal? We either get all 4 under one bond or we don't get any.
I think that still is consistent with the record that's reflected, Your Honor, that...
But back then, you just got 2, did you not?
Excuse me?
In 1989. How many turnpikes were built in 89 out of these 4?
4.
All 4 were built?
All 4 turnpikes were built in 1989, Your Honor. So components of the creek, the first sections of the creek, the John Kilpatrick Turnpike, the Chickasaw Turnpike, and the Cherokee Turnpike were all fulfilled in 1989.
Today, you're seeking to add 2 additional provisions under this section, 2 additional turnpikes.
2 additional phases of the outer loop that was authorized in 1987, Your Honor. You're
So
absolutely
you don't contend those are part of the all or nothing project that then Governor Bellman referenced?
No, I think the legislative history, clearly shows that the intent was if you want to build parts of 2 urban turnpikes, you also have to build at least a part of the 2 rural turnpikes as well. The authority wasn't necessarily happy with that provision as it got enacted in 87. In fact, it tried unsuccessfully to try and get that provision repealed. But instead, it complied with those provisions, constructing at least a part of each of those authorizations, which is what the newspaper articles seem to suggest, that the understanding of the legislature at that time and the general public was if you wanted to complete any of those authorizations, you had to complete at least a part of all 4.
I have one final question and I'll waive. You seem to indicate that the legislature is on board with these due to their failure to amend these statutes. That's what I understood your presentation.
Yes, sir.
Section 28, to me, Ms. Downing, I think, said in her brief, it seems to be a project looking for a statute, not a statute looking for a route. Why not just go to the legislature and get this amended to precisely follow the route that you seek approval for and take this policy dispute to the people's house? Why bring it here?
Because the legislature has already authorized that route, Your Honor.
Thank you, counsel. I have no further questions, Chief.
We're going to go ahead. Time limit doesn't apply to the justices' questions. Do you have questions here?
No questions at this time.
Mr. Winchester?
I have no questions.
Mr. Evanson?
No, thank you.
Mr. Combs?
Not at this time, Chief.
Mr. Scourge?
I wanted to ask if you think that there is a severability clause somewhere in this section that we're talking about. I think that was mentioned perhaps earlier in one of the briefs. Could you give me some information about your position on that?
Sure, Your Honor. In the 72 years that the authority has been before this court, the court has never found that a route does not exist. And that's because the legislature has vested the very broad discretion to determine the location and routes as it determines to be feasible and economically sound. The feasibility of the Tri-City Connector, the East-West Connector, and the South Extension could all be put in jeopardy if the court decides to inject itself into the drawing of the routes for the legislative authorizations. Those proposed alignments all rely on each other, not only from an economic soundness perspective, but also a transportation feasibility perspective. Yes, the court may be able to sever, those particular projects, but it could really throw into jeopardy the other projects as well.
Thank you. I waive.
Mr. Reed?
No questions, Chief.
Mr. Skee?
I just want to talk to you about the the section shall be issued as one issue for all 4 of the proposed turnpikes. Okay? So I thought I heard you say, because I was really interested in 1987 when the legislature decided to write this statute, Would you agree with me that the first part of that section says the turnpike gets to put turnpikes where they need to, and they can get any kind of money from any kind of bonds as long as it's regulated correctly, right?
Absolutely.
Okay, except for some reason, the second part of that is this very distinct two things. One, you have very distinct descriptions of where the legislature wants you to place these highways, ingress, egress, where you place them. That's one issue in this case. Besides that one, then they also decided to say, well, wait a minute. For these 4 turnpikes, we are going to make something pretty specific about how they're financed. And it says, shall be issued as one issue for all 4 of the proposed turnpikes and shall be financed, constructed, and operated under one bond indenture. I understand and I agree with you that the master trust agreement, is one bond indenture. I'm really wanting to understand why you think the legislature thought it was important. Well, let me ask you this question first, sorry. Do you think one issue means in all realms of the banking industry, one series of bonds?
Your Honor, with respect to that first authorization, yes. And the
Okay.
authority complied with that request.
Okay, all right. So you agree that that means one bond issue, and you say that happened in 1989 when they made the master trust agreement and they decided to start building parts of all these highways.
That is absolutely.
Now, why would the legislature care or make it one bond issue for those 4 turnpikes? Do you have an opinion about what the politics maybe was behind that?
Your Honor, I can only speculate, and I guess it's a power play, that there was disagreement between the governor and the legislature. There was a desire to build these 2 facilities centered around the major metropolitan areas. And the deal that was struck is that if you want to build all or any part of expressways around Oklahoma City and Tulsa, you also have to construct at least part of these facilities in rural Oklahoma.
Okay. But why would they limit it to one series of bonds for that?
I think at that time, Your Honor, it was so everything got constructed and they could be assured that those 2 rural facilities would be constructed at exactly the same time as the new issues.
So it wouldn't have anything to do with the fact that they would all be financed under the same bonds at maybe the same interest rate, or maybe the 1961 amendment referendum that said, oh, by the way, all these toll roads are going to keep paying for the other toll roads until they're all done. Do you think any of that financial stress was taken into consideration when they wanted it just to be one bond issue?
Well, I think, Your Honor, I think the real crux is they wanted components of at least 4 of those projects authorized, right? 1989, the amendment of the Master Trust Agreement just happened to be a convenient time to consolidate all of the other issues into one master trust indenture. If you look through the history of, the issuance, you had the first, 5 or 6 series were all single indenture series for each of the distinct authorizations. 66, we get to the point where we can start combining turnpikes between the Indian Nation Turnpike and H.E. Bailey Turnpike.
So your explanation to me is that the legislature was okay with building half a wagon. Let's just build the front, and as long as you're building the front of 4, we'll all be good? Because in 1989, that's kind of what you're saying happened. They just maybe issued this bond to get away with getting through this one issue series?
Yeah.
Okay.
Yeah.
All
And
right.
I think that's the case, Your Honor.
And so then, from here on out, then the Turnpike Authority can issue as many bond series as they want for as many spurs as they want, because you've satisfied the front part of building the wagon and you don't have to follow the one issue for the back half?
That's exactly right, Your Honor. Basically, the authorizations all provide for the construction of all or any part thereof. Not all of the turnpike, it provides for all or any part. And the legislature has vested that exclusive discretion to the authority to determine which parts along such routes and along such locations as the authority deems to be feasible and economically sound.
So if the legislature was trying to get the one issue bond to make sure everybody got a fair shake in the state, rural counties and the big cities. Why would they have written in one issue? Why didn't they just say build all four, and just as long as you build all four turnpikes over, now we're at 30 years, just as long as they're built, that's all we care about?
Respectfully, Your Honor, I think it's because the legislature probably thought that the feasibility of the two rural turnpikes is much less than what the two urban turnpikes would be. And so they had to hamstring those two rural turnpikes with the urban turnpikes to make sure that if all or any part of the urban turnpikes were constructed, at least a portion of the rural turnpikes had to be constructed as well.
And you're getting all or any part of under 1705E, is that correct?
That's correct, Your
Okay,
Honor.
so that's not just where you place it. You're now going to say that that also affects Section F on how you finance it. You're going to link those two together to make your argument work.
1709, the issuance for bonds, Your Honor, is where we get the authorization to construct and finance all or any part of one or more turnpike projects.
Oh, so now you're saying under 1709 that the more general is 1705F is very limited on how and why, but you're saying, oh, but we don't have to look at 1705F anymore because we did that in 1989, and now we're back to 1709, Section 1709, where you can just do general funding?
Your Honor.
Is that your argument?
That is the argument.
Okay.
Because the authority completed that particular legislative authorization to 1705F with its issuance of bonds in 80.
All right. Thank you, sir. I waive.
A few minutes ago, counsel, you said something about, the way I took it, there would be trouble if the Supreme Court ejects ourselves into this process. Isn't that the word you used, inject?
Yes, sir.
You filed it, didn't you?
It did, absolutely.
So what's our function here? What's the function of the Supreme Court?
Your Honor, it's to assert or find, hopefully in our case, that we have authorization under the existing statutes to complete these projects.
Just do it, right?
We have to look at the legislative text and the history, and based on the law that's before us, that the legislature has enacted, and the previous decisions of this court, the authority believes it is operating fully within its discretionary power.
Counsel, I'm old enough to remember in grade school and junior high the introduction of modern math, where 2 and 2 didn't necessarily equal 4. That's what all the parents were saying. It's what I'm reminded of because you're saying 1 really means 2, right?
With respect to what, Your Honor?
Bond indentures.
Your Honor, it's the authority's contention that it complied with the terms of the 87 Act Amendment in 1989 through the issuance of its bonds. It financed those 4 projects under one bond indenture. Consequently, the master trust agreement that was adopted in 89 is still the master trust agreement that the authority goes to every year to finance future bond issues. In fact, this proposed bond issue is the 20th supplemental indenture to that master trust agreement to accomplish these projects, Your Honor.
Anybody else have questions at this time?
Which bonds are you seeking to retire?
Your Honor, there's a 2017A bond issue that if it meets the economic savings requirement of at least 3%, that we would retire those. It would also fix out an interim junior note that was taken out in 2020 as a result of the COVID-19 pandemic due to liquidity issues.
So the 1989 series was completely exhausted.
That is correct, Your Honor, and it's been refunded at least twice at this point.
All right, so it's still current series of bonds.
It's named under a different structure, yes, ma'am. So the 89 bonds are retired, but there was a couple of series that have since refunded those 89 bonds.
So why didn't you seek to refund the 1989 bonds?
Your Honor, those would not make economic savings at this time to the extent that there's any of those pieces outstanding right now.
Chief, if I may. Counsel, what's the duty of the Bond Oversight Committee in this process with regard to one bond issue and bond indenture? Do they review these, and have they reviewed this trust amendment 20 times?
Yes, Your Honor. I'm not sure if they go back all, the way to 1989, but there were actually two distinct, there was a legislative oversight committee and then the Council of Bond Oversight, two different entities. Those have since been merged into just the Council of Bond Oversight. And every state issuer of debt is required to go to the Council of Bond Oversight for approval prior to actually going out and marketing, those bonds. They have reviewed these materials, they've approved this authorization to move forward, and that's why we're here before you today.
Can you tell me when they approved this particular authorization?
Yes, Your Honor, I believe they approved it in late June.
Of 22?
Yes, sir. The authority approved it on June 29th, excuse me, and the Council of Bond Oversight actually approved the bonds on August 9th in special session.
Thank you. Thank you, Chief.
Well, thank you, Counsel. You may have a seat.
Thank you, Your Honor.
Mr. Lester, I believe you're to go first, is that right? You have 10 minutes, correct?
Yes, that's correct.
Thank you, sir. You may go ahead.
Thank you, Mr. Chief Justice, and may it please the court. Words are important. They mean something. This is especially true in the law, especially when reviewing a piece of legislation. As Chief Justice Marshall wrote almost 2 centuries ago in Gibbons v. Ogden, the drafters of a law must be understood to have employed words in their natural sense and to have intended what they said. And this is especially true when reviewing the power of a state agency, for state agencies only have the power to act that the state constitution and the state legislature give to it. Well, the application here, I believe, is straightforward. Section 1705E makes clear that OTA does not have the power to build or finance the so-called South Extension because the legislature has never authorized it. So let's look at the words of the statute. This is 1705E28. The Oklahoma Turnpike Authority is hereby authorized and empowered to construct, maintain, repair, and operate turnpike projects and highways, provided that until specifically authorized by the legislature, the authority shall be authorized to construct and operate toll turnpikes only at the following locations. Now getting to 28, a new turnpike and bridge or any parts thereof from a point in the vicinity of the city of Mustang southerly across the South Canadian River to the H.E. Bailey Turnpike in the vicinity of the city of Tuttle, and then easterly across the South Canadian River to a point in the vicinity of the city of Norman. Somehow, OTA claims that those words, south across the South Canadian River to the H.E. Bailey Turnpike in the vicinity of the city of Tuttle, and then easterly across the South Canadian River to a point in the vicinity of the city of Norman, somehow that gives them the authority, they believe, to build and construct and build and operate a turnpike from Purcell to Norman. And a simple look at the map will show that those two starting points are quite distant from each other. That's not what the statute says. It's not even close. Nothing in 1705E28 mentions Purcell. It mentions Mustang, it mentions Tuttle, it mentions Norman, but it never mentions Purcell. The magic trick that OTA wants you to believe is that the words of 1705E28 don't refer even to a roadway from Tuttle to Norman, which they've now called the East-West Connector. But if that's not what those words are talking about, it's pretty difficult to fathom what those words might mean. Of course, the general rule of this court is that all legislative enactments must be interpreted in accordance with their plain, ordinary meaning, according to the import of the language used, and that the judiciary may not expand the plain meaning of words by construction. So if not describing a road from Tuttle to Norman, what else could it be? How did we get to starting in Purcell? Well, it comes out of thin air. The words of the statute don't come close to describing a northbound road from Purcell to Norman. They describe an eastbound road that starts in the vicinity of Tuttle and ends in the vicinity of Norman. That's what it is. Now, in their original brief filed in August 10, OTA described two parts of its plan as having been authorized in 1987, that's 1705E20, and then the final segment, which again they said here, is authorized in section 1705E28. Well, they're correct, it has to be in 1705E28, but there is no north-south road from Purcell to Norman in section 1705E28, unless the words of the statute are considered nonsense, which I want to quote that legal master, Humpty Dumpty. When I use a word, Humpty Dumpty said, in rather a scornful tone, it means just what I choose it to mean, neither more nor less. But that's not the way this court has ever read a statute. The legislative authorization to move forward is for a road that starts somewhere in the vicinity of Tuttle and ends in the vicinity of Norman. Nothing else. Candidly, using OTA's logic, 1705E28 might be describing a road that, let's say, starts maybe at Highway 51, just south of the Antelope Hills, goes down to Elk City and Altus, goes through Lone Wolf, Hobart, Goaty Bow, Mountain View, maybe swings north to Colony, then back down through Anadarko, Chickasha, Dibble before arriving at Purcell, where it then goes easterly across the South Canadian River, turning north to connect with the east-west connector in the Norman city limits, to quote OTA. Now, I know that sounds kind of silly, but that is no more authorized than is a road starting in Purcell and going to Norman, not in 1705E28. 1705E28 says what it says, and OTA cannot make a roadway that starts in the vicinity of Tuttle and then goes easterly across the South Canadian River to a point in the vicinity of Norman and change it to a northbound road from Purcell to Norman. It just can't. That's not what the words say. And by the way, if you would go to the accessoklahoma.com website that the OTA has set up, you'd find that the proposed roadway from Purcell doesn't actually cross the river in an easterly direction, but in a northeasterly direction. And certainly the word northeasterly, the legislature knows how to use in this statute because it uses it twice in this statute at 1705E10 and 35. The legislature has never authorized a roadway from Purcell to Norman. It could do so, it has the power to do so, it has the right to do so, but it has not done so. To be sure, OTA can even seek legislative authorization, and we heard that they see the legislature regularly, but it hasn't done so, perhaps fearing that the legislature won't agree. But unless and until it does so, OTA has no power to build that road or to issue bonds for it. Unless and until the legislature adopts a statute expressly authorizing construction and operation of a roadway from Purcell to Norman, OTA's plans, concepts, and desires cannot serve as a basis for funding authorization by this court. In our tripartite system of government, courts don't deal with the wisdom, policy, or expediency of a legislative enactment. That's what the legislature does. And this matter is purely the subject of legislative deliberation and cognizance, to use this court's words. Absent express statutory authorization, the decision whether to build the so-called South Extension resides with the people and their elected representatives in the legislature, not with the unelected bureaucracy in the Oklahoma Turnpike Authority. OTA has no legislative authorization to construct or operate this so-called South Extension. Without that authorization, this court may not and should not validate the Oklahoma Turnpike System Senior Lien Revenue Bond Series 2022. Thank you.
Yeah, so I would just say if you're going to go to Colony and Altus, you need to go to Duke also, okay?
There are a lot of choices. I tried to cover as much as I could there.
No questions.
We're speaking of 28. It sounds like you want it very strictly set out as to what that route should be, correct?
Well,
That's your objection, is it's not clear, but if you look at the statute, we've known at least since '89, there was an outer loop going, and that there was going to be something in the vicinity of Norman. You'd agree with that? That
Yes, Your Honor.
You're familiar with that? You weren't surprised that when this came up, were you?
no.
So your objection is it's not specific. Let's go back, if you will, help me. Back up to number 1. And the list is, and I'll read it to you, I don't know whether you have it or not. It says, the Turner Turnpike between Oklahoma City and Tulsa. That gives no beginning or ending point, gives no ingress or egress or access points at all. So how would they have built that under your scenario?
Well, I believe when the statute was written, it was already built, but, so, I mean, there was something called the Turner Turnpike already. So I think that's a little bit different from what we're talking about here. But the other response to that is, in this particular part of the statute, the legislature was specific. I mean, it wasn't general. It didn't talk about the Antelope Hills to Purcell to Norman. It talked about Mustang to Tuttle, and then to Norman.
You don't have any problem with that part then?
No.
Oh, okay.
No,
That
my
part, it's
objection
just
is
the south extension.
South extension that goes from, apparently starting in Purcell and goes to Norman.
And what's the distance from where it starts north of Purcell to, say, Norman city limits?
Well, I'm not sure of the exact distance. I believe it's around 18, 19 miles. Something along those lines.
I have nothing further.
Which Justice Marshall were you quoting?
Well, there are two of them. The great Chief Justice from a couple hundred years ago, not Thurgood Marshall, one of my personal heroes, who I think is perhaps the greatest lawyer that ever lived.
John Marshall.
John Marshall.
Thank you, Mr. Lester.
Thurgood Marshall was an amazing lawyer.
Thank you, Chief.
I do. Mr. Lester, you in essence are arguing severance, correct? You are saying that the legislature did not authorize the south extension as Department of Transportation is proposing it, and therefore it should be severed from this entire bond issue. You have no position, I think, in your response to Justice Winchester with regard to the other extensions, the other two, right?
I do not have any.
You have no
objection
position
to
in
the
them
other two.
whatsoever. You just believe that the south extension was not authorized by the legislature, and on that basis, and that basis alone, this should fail.
Yes. Okay. Yes, Your Honor.
Mr. Gertz? Justice Reeves, do you have any?
No questions, Chief.
Justice Key? Thank you, Counsel. Oh, you have some more?
I have a quick question. Counsel, what do you think the legislature intended in the last phrase of 28? Is that the current Highway 9 route that you contend that they authorized?
Honestly, I think it's the route that they're calling the east-west connector.
About the new one?
Yes.
The proposed one that we're dealing with?
I mean, I think it's at least plausible, but the east-west connector certainly seems like that's what it is. I mean, it starts in Tuttle, where the south part ends, and it goes to east across the river to Norman.
Well, the reason I ask, Mr. Davidson mentioned Highway 9 was upgraded after this legislation went into place with a federal transportation grant, thus no need to bond it as a turnpike. But it's not your contention that the current Highway 9 is what the legislature contemplated when they drafted Section 28?
I suppose it's arguable, but it seems a lot more likely that it's this roadway that goes from Tuttle to Norman.
Let me ask you this. Would this match with the current Highway 9, the language as written here in 28?
I think you'd have to give vicinity a pretty broad meaning.
Does it end in the vicinity of Norman?
I believe it does. I'm not all that. I've been on that road one time that I recall.
Chief, I do have a question. Sure. Mr. Lester, doesn't this sort of hinge on your definition of vicinity? For example, as you mentioned, I'm from Colony. Well, I think of Weatherford as a suburb of Colony. And Eakley and Corn are certainly in the vicinity. So what does vicinity mean?
Well, I think that's a great question, and yes, the definition of vicinity, I suppose, is important. I suppose if we were to start a trip from, say, Minneapolis on the north end of Interstate 35, then pretty much anywhere in Oklahoma is going to be in the vicinity of Norman. I mean, Tulsa's in the vicinity, Colony's in the vicinity, my old hometown Enid is in the vicinity, but when we're talking about a roadway that goes from Mustang to the vicinity of Tuttle, and then goes from there and then to someplace in the vicinity of Norman, I'm not sure how, first off, I'm not sure how Purcell gets into the mix when the road goes south from Mustang to the vicinity of Tuttle, and then the words are "and then." That's what's in the statute. And then, well, that doesn't start in Purcell, which is, I don't know, 35 miles away as the crow flies from Tuttle to Norman. I mean, the question is where, I suppose really not so much the word vicinity, but where does that road start? The road starts wherever the other one terminated, the vicinity of Tuttle.
But it doesn't say where it started, it says where it ends.
The first part says that, correct. The vicinity part is, it's fascinating in the statute. It doesn't say where the roadway is going to start in the vicinity of Tuttle. It says the first roadway ends in the vicinity of Tuttle, and then. So wherever that point is, and then, that's where you're going next. You're going from that starting point where the other road ended. And that's not Purcell. This isn't describing some completely separate roadway that both of them end up terminating in Norman. This is describing a roadway that starts wherever the one going south from Mustang to the H.E. Bailey Turnpike in the vicinity of Tuttle ends.
Thank you, Mr. Lester.
Anybody else? Justice? Thank you, sir. You may have a seat. Mr. Norman? Again, you have 20 minutes, sir, and we'll do our best to allow you to summarize before we ask questions.
May it please the court, I've introduced myself, Robert Norman. I represent the group of Pike-Off OTA protestants, which is Pike-Off OTA, an advocacy group, and 25 individuals who are variously impacted by the turnpikes. I'd like to start off by reminding the court that we live in a country and a legal system that the first principles are the rule of law and representative democracy. People, entities, companies, and above all, the government must conform its conduct to the letter of the law. What the OTA is essentially asking the court to do, and I'll get into specifics, but their overarching theme is they want this court to conform the law to their conduct rather than conforming their conduct to the law. Their linchpin of their argument is a systemic fallacy throughout. It's a circular tautology that basically says, what we have done is legal because we have done it. It finds no support in the statute. Now, I'll get into specific examples, but one correction in the record I wanted to make about what the Council of Bond Oversight did. The Council of Bond Oversight has not approved this bond issue in any form or fashion. The Council of Bond Oversight, and this is all in the party's appendices, the Council of Bond Oversight has done two things. When the OTA sought a $200 million line of credit to jumpstart Access Oklahoma in advance of bond financing, the Council of Bond Oversight said, okay, you can have a $200 million line of credit, but you cannot use that $200 million line of credit for these 3 turnpikes. You can use it for the maintenance projects, for whatever else you want, but the council was adamant at that point that you cannot use this line of credit for these turnpikes, these 3 new turnpikes, the connectors and the south extension, because of the legal issues around them. Then the OTA abandoned their line of credit and sought approval of a bond issue in anticipation of coming to this court. And what the Council of Bond Oversight said is, you cannot issue these bonds for these 3 turnpikes until you get the district court cases, 2 of them, dismissed or otherwise resolved fully and finally in your favor, and you receive validation from the Supreme Court for your bond issue. So the Council of Bond Oversight has not given this proposed bond issue a pass. They have specifically carved these 3 turnpikes out and ultimately said, this is an issue for the courts to decide. This is properly an issue for the courts to decide. Maybe they should have decided it in the first place, but because of the existence of legal proceedings, they deferred to the courts to make the decision. They have not approved this bond issue. So there. Pikeoff is going to take on both of these little sections, both of these components. First, the 1705F restrictions on the east-west connection and the Tri-City Connector. And of course, the lack of legislative authorization for the south extension. First, as to 1705F, the language of the statute, once you break it down and put it back together again, you have to read, you have to look at a little law on what one bond issue is, but once you settle in and read that, great clarity comes. And the OTA has essentially conceded that what it means is that all 4 of the turnpikes, 10, 20, 21, and 22, had to be bundled together and constructed together under one bond issue and one bond indenture. So it's a double restriction. They can't just comply with one without complying with the other. So we can ask, did they comply with the one bond indenture requirement? Well, whether they did or didn't, they still have to comply with the one bond issue requirement. They've essentially conceded here today and in their supplemental briefs that what they're doing now are subsequent bond issues. It's kind of the 1 + 1 = 2. 2 + 2 = 4. Something I heard today that I've never heard today before is that they've actually done 7 bond issues now between 1989 and today. I don't know if this one counts the 7th or this one would be the 8th, but they've conceded that we've done 7 bond issues for basically the Oklahoma City outer loop by itself. How many times have they come to the courts for these subsequent bond issues after 1989? Once. What the OTA has essentially done, and I'm not saying it's malice or it's purposeful or they're trying to purposely do something in bad faith, but they have come in under the radar screen and violated the statute a number of times. The one time they came before the courts, and there are some of you here who were on that panel, one of you here authored the opinion, the exact meaning of 1705F and the consequences of 1705F were not brought before this court. There were 2 kind of wrong fork in the road arguments. Single subject, which wouldn't have made a difference in the case anyway, but the court rightly rejected it, and a rule against perpetuities argument, which wasn't a very good argument, and the court rejected that too. What is squarely before the court today is squarely before the court for the first time. Now, the OTA having conceded that they had to do one bond issue for all or part of the 4 turnpikes together, and we agree it can be part, it can be part or all, but the 4 have to be together. You know, the wagon has to be constructed together, and you can't put one wheel of the 4 wheels of the wagon by itself ever. Now, what the OTA, again with a new argument, is saying, well, we agree with that, but it only means the first time we took a shot at this did we have to put these together. That's not what the statute says. The statute says any bonds shall issue as one issue. Any bonds. To make the OTA's argument work, the legislature would have to have drafted the statute or amended the statute at some point to say, the first time any bonds are issued. They shall be issued as one issue. So yes, we all agree that in 1989, the OTA complied with the 1705F mandate by putting segments of all 4 turnpikes together into one bond issue and constructing them. But then, according to the plain language of the statute, they were done. It's game over until and unless they get 1705 amended. And they knew it. They knew it before they came to this court. They're out there in 1987 and 1988. Governor Bellman himself, who is the OTA de facto, this is his baby. He's on the OTA board. He appoints the OTA board. He appoints the executive director. He can remove and put them on. This is Governor Bellman's baby. He's going all over the state, telling the news outlets, this is an all or nothing deal. The legislature has tied our hands and made us put these 4 facilities together. We need to get this statute amended to separate the projects so we can build the ones that are really feasible now and save the rest for later separately. But the legislature never amended that statute. And the point is not, the process or why it failed or how it failed or whether it died in committee or whether it died on a no vote. It actually died on a no vote of the whole legislature. The point is that the OTA brain trust, Neil McCaleb and Governor Bellman at the time, knew they were up against a wall. And their problem was they were trying to do it all. But they'd gone in and done feasibility studies and figured out we've bitten off more than we can chew. And so as you see the evidence go, you see this 4 turnpike bundle getting scaled back to smaller and smaller and smaller segments until they come to this court in 1989 with what this court properly validated. There was no doubt but what they were doing, one bond issue for segments of all 4 turnpikes, and that was okay. But then they were done, unless they got 1705F amended. Now, could you construe the statute to say, well, they can do more than one bond issue multiple times? Well, even if you construed the statute that way, they still got to put all 4 wheels of the wagon on the wagon. Even if you say, okay, that statute means they can take more than one crack at one bond issue, which it doesn't. You'd have to again put something in front of the statute that says any time the OTA issues any bonds. And it doesn't say that. It just says any bonds. Any bonds means any. 1989, 2022, 2016, 2030, 7 bond issues that have gone in under the radar screen. Any bonds means any. But even if you want to liberally construe that statute to say they get more than one crack at it, they still have to put those 4 turnpikes together, segments of those 4 turnpikes together in doing so. And they're not doing so here today. The OTA also concedes that the legislative intent, which I think it did have something to do with financing. It was don't linger. It was get going, get moving, get this project done, don't let it linger. There was a financing aspect to it that we see going on in the legislative history where they're bumping up against financial problems. But it also was, as the OTA says, don't leave out the rural folks. Put them all 4 together. And that didn't just mean the first time. What the OTA is trying to do and what they have done systematically since 1989 is they've left out the rural folks. What did they do in 1989? They built a little 2-lane stick that we call the Chickashaw that goes between Davis and Ada. It's a very small isolated part of that authorization in Section 10. They're not including more authorizations they're not including more segments for Section 10 today. They didn't in 2016. And quite frankly, that's a violation of the statute. And if they have, again, under the radar screen or the first time out, completed the Creek and completed the Cherokee, that's the consequences of their choice. If they can't put all 4 together now, that's the consequence of their choice, and that's the problem they have with the statute, and it's a legislative solution, not a judicial solution. They need to go back to the legislature and amend F, and until and unless they do, they can't do this. They can't do this for 2 reasons. They can't do it at all because they're doing a subsequent bond issue. 2, they can't do it because they're trying to do the Oklahoma City outer loop by itself. Another new argument, they've said, well, in 1989, the proposed turnpike authorizations became constructed projects under 1704-2. That's true, but it doesn't mean anything for this case. Why doesn't it mean anything for this case? Because the East-West Connector and the Tri-City Connector are right now proposed turnpike projects. They say as much on page 1 and page 4 of their original brief. They say on page 1, what we're seeking this court to do is approve proposed bonds. And on page 4, they describe the connectors and the south extension as proposed turnpike routes. That's the only way to construe these. Their construction, the proposed argument means nothing. Because what it has to apply to is what they're trying to do now. What they're trying to do now is proposals. So they fall squarely within the meaning of the statute. Now, on to the south extension. The meaning, vicinity of Norman does have some meaning, but we can't get too hung up on it in isolation. We have to read that statute as a whole. And in front of vicinity of Norman is a mandate to move from the H.E. Bailey Turnpike in the vicinity of Tuttle easterly across the Canadian River to a point in the vicinity of Norman. Not we get to tag off the H.E. Bailey Norman Spur or Highway 9, which that is the continuation of the 28. It's just they did it as an ODOT project instead of a OTA project. That would be an authorized alternative route. That would be an authorized route for the terminal part of 28. Would be to move along. You could wobble a little north or south of that and move in an easterly direction. It's not due east, it's easterly. But the mandate is singular. Once you hook up with the H.E. Bailey Turnpike in the vicinity of Tuttle, which they've already done with the spur, you have to move easterly. You can't dump down southeasterly to Purcell and then dump back up northwesterly and due north through rural McLean County, rural Cleveland County, through the entirety of the up-down city limits of the city of Norman, just on this side of Lake Thunderbird, endangering the watershed, and hook up with the east-west connector. Again, they would have to amend the statute to basically say easterly from the H.E. Bailey Turnpike, and then southeasterly down to the vicinity of Purcell, and then again northwesterly and northerly up into the vicinity of Norman. They have a singular mandate which restrains them, and it's an L. 28 is a southwestern L. It's not a stick that goes south and then gets to make a V back up again. The legislature is not directionally challenged. Anywhere and everywhere in that statute, after we get past 6, we used to, originally the legislature just said, well, put it anywhere between Tulsa and Oklahoma City, the term. Now, they are more specific about their legislative authorizations. And this easterly mandate is the doom of trying to put a turnpike down to Purcell. Whether in a global sense Purcell could be in the vicinity of Norman or not, it's a separate township, it's in a separate county. It's no more in the vicinity of Norman than Piedmont is in the vicinity of Mustang. And we would not say in a million years that the OTA is authorized to start 28 somewhere in Mustang, jump up to Piedmont up north, and then jump back down south and back down to Purcell. It's not a Piedmont to Purcell authorization. But that's essentially what they're saying. They're essentially saying it's a Purcell authorization, but it's not because of that easterly mandate. We don't have to get too hung up on what's in the vicinity of Norman. If we didn't have any mandate, hey, that might be dispositive, and that would be a fact question, by the way, that needs to be resolved by a district court rather than a Supreme Court. But we can see from the easterly mandate, there's a little wobble room there. But if you look in our appendix, we present a compass rose, and we put that compass rose on this proposed route. And you can see, looking at our appendix, looking at just a good old-fashioned compass, what this route does, extending from the H.E. Bailey Turnpike or the terminal of Highway 9 and I-35. It goes southeasterly at best, really probably south-southeasterly to get to Purcell, and then jumps back up again northwesterly and due north up to a point in northeast Norman. It violates the easterly mandate. Council mentioned, well, we have the discretion to do a perpendicular and easterly route. No, you don't. Perpendicular's not in there. It's parallel. It's an L, not a V. That is not what it is. And kind of their cases, to briefly go into their cases, the 1989 case did not approve putting this together in segments. The 1989 case, this court merely borrowed the OTA's language of Section 1, Section 1, Section 1, Section 1. And by the way, it was Section 1, Section 1, Section 1, Section 1 as to all four parts, is what the OTA represented it as, which would say that if the OTA thought that they could continue on in sections, they had to still put all four of them together later on. So 1989 does not say what the OTA says it does. Neither does 2016. Anything that the OTA is quoting in 2016 is, again, the court expressly stating the OTA states that, not we hold that. The OTA states that, not we hold that. And also the OTA, kind of to wrap up this summary of the argument, the OTA basically says this is not the job of the courts or of the legislature or of the people. This is our sole discretion. Well, every time they do that, they leave out the most important part of the statutes and the cases. The statutes and cases all say, no, the first question we ask is the route legislatively authorized? Has the legislature authorized the route? It's a defiant statement from the OTA that violates the rule of law. It is them trying to say, this is the rule of the OTA, not the rule of law. The courts don't have any business inquiring of us. The legislature has no business inquiring of us. We just get to decide. No, the statutes don't say that. The statutes don't say that. The statutes say the legislature, the people's representatives, get to decide. This is a rule of law and a representative democracy violation. None of these three routes are legislatively or lawful for the OTA to build.
Ms. Norman, severance was mentioned a few minutes ago. What's your opinion about that?
Severance in the sense of, as I understand the severance proposition is kind of what the Council of Bond Oversight did. The Council of Bond Oversight said, well, you can have a line of credit for the Turner, the Kilpatrick, all your maintenance and your widening projects, but you can't have a line of credit for these three turnpikes. I believe the court could do the same thing here. Pike off OTA really has no position on whether they can do a $50 million refinance. That's not here. If they want to do a $50 million refinance, fine. We're not challenging that. If they want to do a bond issue for their Turner projects, for their safety projects elsewhere, we have no position on that, and we have no challenge to that. Now, they've kind of invited confusion by not really factually coming in and saying, this is how the 450 breaks down. We're doing this work on the east-west, that work on the Tri-City, and this other work on the south extension, and we need to finance it, and then $200 million worth of work on the other. But I think this court, from the standpoint of making rulings of law, as this court often does, it's almost a reverse and remand thing. This court can say, no, you are not legally authorized to issue bonds for these three new turnpikes. Now, you can go and figure out how to issue bonds. We express no opinion. There's no challenge. We do not disapprove. In fact, we would validate bonds for the Turner, the refinance, things like that. And OTA, you can go and figure out how you want to divvy up that money, but you're not, as the Council of Bond Oversight said, you're not divvying up any of the money for the three new turnpikes, in other words. So in that sense, there is a severability option. This court can make kind of a declaratory ruling that No bonds for the 3 new turnpikes, but okay, if you need to do a bond issue for a refi, if you need to do a bond issue for the Turner, the Kilpatrick, fine.
No questions.
Judge?
None.
Simpson?
Then one of the 3 cannot be severed. All 3 must be severed if we're going to look at severability.
All 3 are legally unauthorized, for 2 different reasons. All 3 are legally unauthorized for 2 different reasons. The east-west connector and Tri-City connector is a 1705F problem. It's not an E problem.
I understand this.
Yeah. You could. That's among the available discretionary options. Again, the OTA has kind of muddied the waters themselves by just throwing a big old bond issue at you and not really saying what this, that, and the other is for. But let's say, for instance, the court determines, okay, south extension is okay, but the connectors aren't. The court could validate bonds for the south extension. Or the other way around, east-west connector is not okay, it is okay, but south extension is not. Yes, you can.
Thank you.
Now the Tri-City connector and east-west connector kind of come in together. They're both 1705F problems. So I don't think you can do it 3 ways. You can do it 2 ways. Okay.
Thank you. Thank you, Chief.
No.
Well, it's interesting listening to the presentations this morning that I think everyone agreed that when this initially was determined by the legislature to allow for these turnpikes, that the legislature was concerned about protecting rural Oklahoma at the same time that they were cognizant of the needs of urban Oklahoma. And yet, what we're talking about today is to the detriment of rural Oklahoma, even without really a good option on how to assist urban Oklahoma. Am I wrong here?
As a policy matter, yes, to a degree. What is unique about this case is that the majority of these new turnpike routes would cross a very special part of Oklahoma. That, in other words, is a little bit settled to a point where what the OTA would do is destroy exponentially more homes and families, disrupt more families and properties than it ever has before. But what the city of Norman has done, not to step on their toes, and they can clarify if the court needs them to, what the city of Norman had done is they have kind of set up a special place by Lake Thunderbird where these turnpikes are going to run, where yes, we can live there, but we're not going to have tract houses, we're not going to have masses of convenience stores, we're not going to have mass suburban or urban development. We're going to have kind of sustainable development that maintains this kind of special rural character for wildlife, for farming, for ranching, for recreation, for the watershed of Lake Thunderbird, an endangered, already known to be a compromised lake. We're going to do a balance. We're the 3rd largest city in the state, and we're going to have mass urban development, but we're also going to have lower level rural residential development. And that is what these 2 turnpikes would interfere with in a way. So they would interfere with something that's kind of unique in the state of Oklahoma, as far as I know. We probably have it in some other places in the country. But this concept of rural residential is the concept of the city of Norman. And the OTA has paid no mind to that whatsoever. They haven't done any due diligence, any feasibility on this. For all we know, they didn't understand that this is what they were doing. Was that they were kind of tromping on both ends. They were tromping on urban ends and rural ends, and they're kind of leaving out the rural interest down south in continuing on with safe roads that connect distant places while trying to do preference to Oklahoma City by completing an outer loop.
I'm sorry, Justice Reef, do you have any?
No questions, Chief.
Justice King?
Okay. I'm trying to put my mind on what you said a minute ago about the one bond issue and the all or any part of. So why, if you have an opinion in 1705E, where it's authorizing the directions of everything, would the legislature say all or any part of? Why would you build a highway to nowhere?
Well,
Can someone else finish it for them?
now, to tell you
Can
the
someone
truth-
besides the Turnpike Authority finish that road? Is that why it says you can just agree to build part of it?
Well, yes, somebody besides the Turnpike Authority can finish that road, and that's exactly what we found has happened mostly with Section 28. ODOT basically took over most of Section 28 except for the spur. ODOT, with a grant, took Highway 9 and widened it to I-35, and they did the Mustang Bridge. They did the first bridge crossing. They got from the H.E. Bailey, they got from Mustang South to the H.E. Bailey Turnpike.
So then let's go to 1705F, where it's talking about one bond series has to be issued for all 4 proposed turnpikes. Are you arguing, or did you say, well, they can propose to build half the wagon or 2 roads to nowhere and 2 full ones, but once you make that proposal, you're done, because that's what the statute provides for?
They are done with what the statute provides for, but they didn't really build a road to nowhere, anywhere here. They had the discretion to do part. Now, building a road to nowhere, they could get out to the point of extremes where they're violating the intent of the authorization in the first place. The closest thing to a road to nowhere here is they kind of, what I would say, gypped southern Oklahoma with the Chickasaw Turnpike a little bit, because they were hamstrung with feasibility issues, but they didn't build a road to nowhere.
Well,
They built a road from basically Davis to Ada. So yes, they did make one meaningful connection there, but only one piece.
and maybe I'm not putting that correctly. Maybe I should use my little wagon analogy instead. But when we're saying one issue, and this is interesting when you were talking about when the governor was running around trying to figure this out. So we have this, any bonds, one issue under one bond indenture for all 4 turnpikes. In other words, the legislature's like, build all of them all the way around, one bond issue, and one series of bonds. And are you saying that they went, wow, that's a lot? So when in 1989, they decided to do what they wanted to do in their proposed turnpikes for that and issue one series of bonds to construct only those turnpikes. And they could do that, and then they're done,
Yes.
period. Then, if the statute isn't satisfied, you agree, or you would argue that that the Turnpike Authority doesn't get to go over to 1709 to start funding what they didn't finish. They have to get the legislature to approve statute for other bond issues and series to construct or finish any loop or spur or anything else.
Absolutely. That's exactly what Henry Bellman and Neil McCaleb understood the statute to mean in 1987 and 1988.
Okay.
And that is exactly what the statute says.
All right.
1705F controls specifically over 1709, which is the agenda.
Okay, and I have one more question. And I understand in 2016, this wasn't a question before the court when those other bond series were issued and approved. If we decide now that these aren't under the statutory scheme, what, if any, legal ramifications do you think it will have on the 2016 bonds?
None.
Why?
Because once bonds are issued, there are statutory provisions, I believe it's 1732. Once bonds are issued and the roads are laid, you really can't go back and unravel what is done. There conceptually is in the statutes, and there conceptually is in the law, kind of sense of finality. In other words, from a
So the lawsuits that are going to be filed, if we do decide that, the response is going to be, well, too bad, it's already done. That's the legal reasoning that we would be like, too bad.
Well, we're out doing a little advisory opinion now, but I would think that we can't literally unlay the Kickapoo Turnpike, and we can't literally, because there are safeguards both in the
Well, sure, you can't do that to the road, but the bonds that are financed.
No, the bonds are out there, The judgment itself, the judgment itself is final.
Okay. Thank you.
I don't know, I may be stepping on some eminent domain lawyer's toes who's going to run out there in a pending case now and try to invoke this and let them have at it. But my thought is the fear of somehow this messing up bonds that are out in the market and performing, that's not there because they're out there issued statutorily and at common law. The court's judgment in 2016 is final, but what it isn't is it's not precedent for the 1705F argument we're making here today.
All right, thank you. I waive.
To follow up on Justice Edmondson's question on severability, suppose the court does sever the application approval, denying in part, affirming in part. What's the mechanism thereafter? Would the OTA need to go back to the Council on Bond Oversight and reapply based upon the decision of the court?
I think that would be the wisest course of action, again, because the OTA has just kind of thrown this at the court. And the only segregation they've done is $50 million for refi and $450 for access.
But ultimately, it would fall back to the Council on Bond Oversight.
Yes.
To follow our opinion.
Yes.
And to render guidelines accordingly. Is that right?
Yes. The OTA could try to say, okay, we've got our guidelines from the court and we're just going to comply with it, which they said with the Council of Bond Oversight, we'll comply with it, and we'll just arrange our affairs accordingly. But I think, yes, the best legal course of action is to go back to the Council of Bond Oversight with a bond issue that conforms to the court's opinions and say, approve this.
Anybody? Thank you, Counsel. Rebuttal?
Your Honor, we're here today because of 1718 in the Enabling Act. And that provision provides that once an opinion is rendered by this court, that any bonds issued under that authority shall be incontestable from that point in the state of Oklahoma. It's important because going back to the COBO issue, the Council of Bond Oversight did approve this bond transaction subject to the recommended conditions. COBO approves every transaction subject to the recommended conditions. Most of those are ministerial, regarding filing of the final official statement, the execution of pricing of the bonds, filing of the preliminary approval fee form, for the bond issuance with the Deputy Treasurer for State Management. In this case, it also conditioned the resolution of the district court proceedings and validation to resolution to provide that the authority had authorization to construct these particular projects. We are complying with that, and that's why we're here. One of the recommended conditions is to obtain validation to provide a surety to the future bondholders of the authority. Second, there seems to be a lot of confusion that the protesters can't even agree on what subsection 28 says. And that's because it's very broad. The authorization provides for a turnpike facility from the vicinity of Mustang to the vicinity of Norman. The city of Norman seems to contend that the east-west connector is the facility easterly and across on Highway 9. That's incorrect. The east-west connector is found in subsection 20 in that authorization, and it says, and I quote, and then south and east to I-35 in the vicinity of Moore and Norman, and then extending east and north to I-40 east of Tinker Field. The subsection 28 authorization is and then easterly across the South Canadian River to a point in the vicinity of Norman. We're talking about the South Canadian River crossing to end in a point in the vicinity of Norman. That's the particular authorization we're talking about here. They also note that they use the directionally term easterly. There's plenty of ample evidence in the authorizing statute that if they wanted to be specific, they could. The legislature chose the broader term easterly, not east, not due east, recognizing that there were going to be several potential challenges with respect to constructing facilities along I-35 and accomplishing that South Canadian River Bridge crossing to end in a point in the vicinity of Norman.
Council, let's look at 28 one more time. There have been several descriptions of that this morning that the language indicates once we get to Tuttle, the vicinity of Tuttle, and then easterly. Your position, as I understand, jumps from Tuttle to Purcell and picks back up at a beginning point. Does it not?
Your Honor, that's essentially correct.
So does the statute say that?
The statute authorizes...
It's just a yes or no. Does it say that?
Yes, because it allows us to move easterly, that general broad description. Though the Turnpike has not constructed that facility from Highway 62 to I-35, doesn't foreclose it from constructing that facility in the future.
Do you contend that you have to cross the South Canadian River to comply with the statute?
Absolutely, Your Honor.
You have to cross the South Canadian River.
If at least a portion of the Turnpike facility authorization has to. It doesn't say you have to cross it easterly at a straight line. It says you must accomplish, it says, across the South Canadian River to a point in the vicinity of Norman. We are crossing the South Canadian River.
Does it not seem to you that as you go east across the river that this statute contemplates that this route would end, not begin, in the vicinity of Norman?
Your Honor, it's our contention that it does end and that it's within the authority's discretion in 1705E to determine the terminus of that facility. And it makes the most transportation sense to tie that connector to the existing to the proposed east-west connector to make sure there's continuity of transportation service throughout the entire area. It would make absolutely no sense to construct an express highway and dump everybody in the middle of a populated area such as Norman.
Questions?
When are you going to finish the turnpike that ends in the vicinity of New Orleans?
I wish I knew the answer to that, Justice Evanson, although I would frequent it.
Send me a postcard.
I just have one question so that I understand. Do you have to have the south extension to do the project to make sense either from a physical standpoint to move traffic off or to be able to pay for the bonds? Is it essential?
It's both, Your Honor, because what we've really tried to set up is essentially everything that has occurred from the 1993 feasibility studies has actually occurred. Traffic has continued to back up along the I-35 corridor. And what the legislature has decided is with these specific authorizations, the authority is in a better position to construct those turnpikes. These have particular importance around metropolitan areas because their use is much higher than what the rural area is. And that provides ODOT the capability to finance construction projects in rural areas, relieving that pressure off of the state tax-supported system. So ODOT can focus in those highly sensitive rural areas, as it has continued to do for the last several years, while letting voluntary users pay for these facilities through access of the OTA.
And one other question, just as I look at the map, from where you would get off on the south extension, which looks like about a mile north of Purcell.
Yes, sir.
From there, that cutoff point to, I think, the South Canadian River is the Norman city limits.
That is correct.
How far is that?
Yes, so Your Honor, so from the I-35 connector, and to be clear, when the statute was passed, Purcell had not annexed that far out to I-35. The river crossing occurs within the first mile, immediately turns back to the north of the vicinity of Norman. From that first spot, it is 7 miles from that extension to Highway 9. From Highway 9 to the east-west connector is another 7 miles approximately, Your Honor.
7 miles?
Yes. It's within a mile and a half of the Norman city limits to Etowah Road once it crosses the South Canadian River.
Thank you.
Mr. Gertz? Mr. Keen? Anything else to say?
No, sir.
All right, this has been case number 120619. It does stand submitted. We'll be in recess. Clerk?
All right.